Let's continue our discussion of employment discrimination with Part 3, and we'll start looking at some of the specific statutes and their requirements. So first, we'll begin with Title VII. Title VII prohibits employers from discriminating or retaliating against employees because of that employee's or the applicant's race, sex, color, religion, or national origin. At some point, I think it was 1978, after some courts ruled that sex did not include pregnancy, Congress enacted the Pregnancy Discrimination Act, which amended Title VII to prohibit discrimination and retaliation on the basis of pregnancy, childbirth, or resulting medical conditions from the pregnancy and childbirth. So Title VII's prohibitions on sex discrimination include sexual harassment. There are two known forms, recognized forms of sexual harassment: quid pro quo sexual harassment and hostile work environment. For a quid pro quo sexual harassment, to prevail, the employee must show that he or she was a member of a protected class. In this scenario, the quid pro quo, it's going to be the protected class of sex. They must show that he or she was subjected to an unwelcome sexual harassment in the form of sexual advances or requests for sexual favors. The harassment complained of must be because of sex, and then the submission to unwelcome advances was either an express or implied condition for receiving job benefits, or that the refusal to submit to the supervisor's sexual demands resulted in tangible job detriment. And lastly, the existence of respondeat superior. And when we talk about these claims of sexual harassment, you probably most often would think of a male harassing a female, and that's possible, and it's the majority of the time. But it's possible that the harassment can occur between a female that's harassing a male subordinate employee. There are cases where that's happened. You could also have male on male or female on female harassment. And so you can have quid pro quo or a hostile work environment be in other dynamics than just a male harassing a female, although that is probably the predominant or primary form that you see these cases occurring in. So under the quid pro quo sexual harassment, not all sexual advances are prohibited or going to arise to quid pro quo sexual harassment. It's only those advances that are unwelcome. So consensual advances or sexual advances or sexual acts that happen between employees, even if it's a supervisor and insubordinate, if it's consensual, then it's not going to constitute quid pro quo sexual harassment. Now, if a consensual relationship oftentimes can turn from consensual to unwelcome, and at the point that the consensual nature stops and the employee says, "No, we're done," and the advances continue, then they can become unwelcome advances. But to be an unwelcome advance, the employee must have either neither solicited it nor invited it and must regard it as undesirable or offensive. So evidence that the employee engaged in similar behavior to that which they claim was either unwelcome or offensive is going to be evidence that the behavior was not unwelcome. So defended a case where the lady claimed that it was a quid pro quo relationship, but our client had text messages from their relationship, and the text messages clearly showed that she engaged in the same behavior that the individual did, the supervisor did, and she had even made comments about the mutual relationship of their feelings. And so those established that the employee was engaging in similar conduct that she now claimed to be unwelcome and offensive. And in our case, the EEOC dismissed it and no lawsuit was ever filed. So the employee must also show that the submission um, to the unwelcome conduct was either an express or implied condition of receiving job benefits, such as a promotion or more duties, or they've got to show that the refusal to submit to the sexual demands resulted in a job detriment, such as a loss of a promotion or a cut in pay. Now, in our case that I just referenced on the previous slide, it was also the employee was unable to establish that the submission of the unwelcome conduct, the conduct that she claimed was unwelcome, she couldn't show that it was an express or implied condition for her to receive job benefits. She didn't have any basis for arguing that, well, she had to submit to it in order to receive a promotion or get additional job duties or obtain additional pay. She didn't have any proof of that, nor did she allege that. Also, she didn't allege or prove that the refusal to submit to any sexual advances resulted in a job detriment. She didn't establish that her job was harmed by it. She claimed that she lost her job, but we had her text message where she texted her supervisor, which was different than the employee that allegedly engaged in quid pro quo sexual harassment, in which she told voluntarily in a text that she was quitting and leaving to go take a different job. And so that cut against establishing that her refusal to submit to a sexual demand resulted in a job detriment, or that her receipt of job benefits was a condition upon her submission to the unwelcome conduct. The lack of an unwelcome relationship or an unwelcome advance, and the inability to establish that the conduct was conditioned upon receipt of a job benefit or the refusal resulted in a job detriment. Those are the two most common elements that an employee can't establish in these claims. So the other form of sexual harassment is a hostile work environment. Now, I just want to note before we go too far in that a hostile work environment can exist based on other protected classes. You could have a hostile work environment based on race. Um, and so to prevail on a hostile work environment claim, the employee has to show that he or she is a member of a protected class. They must show that they were subjected to unwelcome harassment, that the harassment was based on their protected status, that the harassment created a hostile work environment, and the employer failed to take reasonable care to prevent or correct the harassing behavior. So the Supreme Court, the way they've defined it as a hostile work environment exists when the workplace is permeated with discriminatory intimidation, ridicule, and insult that is sufficiently severe or pervasive to alter the conditions of employment and create an abusive working relationship. This is seen to be a high standard. It takes more than, as we'll see in a second, just sporadic incidences and offhand teasing, things of that. It's got to be conduct that's sufficient to be so severe, so pervasive that it's sufficient to alter the terms and conditions of your employment. So this requires both meeting an objective and a subjective standard. Objectively, the conduct must be severe and pervasive enough that a reasonable person would find it hostile or abusive. Then at the same time, the actual victim, the actual plaintiff, must have subjectively found the environment to be abusive. So courts consider the totality of the circumstances, just not isolated incidences. Harassing must be ongoing rather than just a sporadic or isolated events. Simple teasing, offhand comments will not amount to a hostile work environment. And the way that the Supreme Court has phrased it is Title VII is not a code of workplace civility. It's not meant to protect you against mean jokes, rude comments, things of that nature. And the harassment must be due to the protected class. I've had a number of these cases where the plaintiff, when you get in there and you take their deposition and you say, hey, tell me what happened that constitutes a hostile work environment. Tell me all the incidences that establish a hostile work environment. and it'll be based on their sex, and it will be, well, this person was mean to me, and they wouldn't let me change the TV remote, and they um, made fart sounds with their armpits, and they uh, made rude comments, and they uh, didn't like my shoes. There would be this long list of things that they did, but it all went back to that notion that Title VII is not a code of workplace civility. It's not a code of conduct. It's not meant to say, hey, you guys got to get along. You can't, force her to watch TV. You can't, um, be mean to her or say those jokes. It's got to have a connection that the conduct is happening because of her status as a female, and forcing her to watch uh, racing on TV or whatever the alleged conduct may be, as long as it is not related to the fact that she's a female, then it's not going to be sufficient to establish a hostile work environment. And so I've had a number of these claims where they may list 10 or 12 incidences that happened, but then when I look at them at the end of the day, 10 out of those 12 things have no connection to the status of being a female or the status of race. So let's consider an example here. You've got a case where a plaintiff alleges a hostile work environment based on these facts. Number one, uh, the plaintiff's supervisor placed his hands on the plaintiff's shoulder and rubbed the shoulder for approximately 5 seconds while in the plaintiff's office. Next, at a Christmas party, the supervisor grabbed the plaintiff's buttocks while the plaintiff was leaning against the stove at the supervisor's home. The plaintiff objected, stating that she would be fired if she did that. And the supervisor responded by saying that he, quote, controlled the plaintiff's ass and he would do whatever he wanted with it, end quote. The plaintiff later went to the supervisor's home to help repair the supervisor's deck. The supervisor told the plaintiff, let's get it finished so you and I can try the whirlpool out together. Next, the supervisor invited the plaintiff and her boyfriend over to swim. The supervisor remarked that to the plaintiff that the next time you ought to come by yourself and enjoy yourself. And then later, the supervisor was upset because the plaintiff had lied to him, and the supervisor put his fingers on the plaintiff's mouth, then placed his hand on her and pushed her towards the door. So it was these 5 things that occurred over the course of a couple of years that the plaintiff alleged amounted to a hostile work environment. The court said no, the conduct is not sufficient. It's not severe or pervasive enough in which to constitute a sexually hostile work environment. And so this just gives you an example. You may look at this and think, oh, these are bad things, and that you could infer things about it being inappropriate, like the next time you come, you ought to come by yourself and enjoy yourself. That you could definitely infer sexual type nature to that statement. But this being said, and what was said, and it occurring over the course of a couple of years, was not severe and pervasive enough. These were more isolated and sporadic incidences such that they were insufficient to establish a hostile work environment. Okay, switching from Title VII to the ADEA, this is the law that prohibits, makes it unlawful for an employer to either fail to hire or to discharge any individual or discriminate against any individual with respect to their compensation terms, conditions, or privileges of employment because of the individual's age. This is what prohibits age discrimination. And it defines the protected class as anyone that's 40 or older. And so if you're 40 or older, then you're in the protected class. So to recover in these cases, the plaintiff must prove that age was the but-for cause of the challenged employment decision. So if they were terminated, they have to prove that but for their age, they would not have been terminated. It's insufficient to show that age was a motivating factor in the adverse employment action. So they may be able to establish that age was one of a couple of reasons why I was terminated. If you establish that, that's not enough. You've got to establish that age was the but-for reason for the termination. But for your age, you would not have been terminated. For an employer to take an adverse action because of age, that means that age was the reason that the employer decided to act. And so it's got to be close to a sole causation. It can't be because of your age and your poor job performance. It's got to be your age was the reason that the employer decided to act. So we talked about in our previous session about the method of proof through direct evidence or indirect evidence. Both indirect and direct evidence could be used to prove an ADEA claim. So to be in the protected class, like I said a second ago, you've got to be 40 years or older. So if you go back and think about, we're talking about establishing the prima facie case, the fourth element was replacement by a younger employee, or establishing that a younger employee was treated more favorably. Well, for the person to be a younger employee, the worker must be, quote, significantly younger than the plaintiff. And so the courts have kind of developed this test for determining when a person is significantly younger. If the age difference is 6 years or less, then that's not significant, meaning that you can't establish a prima facie case. If you're 60 years old and you're terminated and they hire a 55-year-old to replace you, that's only a 5-year age difference. That's not going to be significant. That 55-year-old is not going to allow you to establish the fourth element of your prima facie case. But if the age difference is 10 years or more, then you're going to be able to establish a prima facie case. So if they hired a 50-year-old, then you're going to have a prima facie case. But if it falls in between 6 to 10 years, then that's done on a case-by-case basis, and it's may be considered significant enough, or it may be found to be insignificant. So it's interesting to note that you would think that in order to be within outside of the protected class, that the person would need to be under 40. But this test shows that the person can still be over 40 and be able to help establish a prima facie case of age discrimination. They just have to be significantly younger than you, which is going to be 10 years or younger, or it may be between 6 to 10 years, depending on the facts of the case and what the court may decide. So for the ADEA, you have to also consider whether the employee was actually replaced. So if the employee, if their job duties are absorbed by another person, the work is distributed among several other employees, then there's no replacement. Rather, the position is seen as being dissolved, absorbed by others currently working. But there is a replacement when another employee is hired or reassigned to perform the plaintiff's duties. So if they hire someone else, it's going to be a replacement. If they reassign Joe from another department to do it, then that's going to be a replacement. But if the duties are given to Joe to do in addition to his other duties, then that's not going to be a replacement. So the ADA refers to the Americans with Disabilities Act. So this is the federal law that prohibits employers from discriminating a person with a disability. It prohibits discrimination, but it also requires employers to work with disabled employees to help him or her perform the essential functions of their job. The ADA protects employees who either have a physical or mental impairment that substantially limits one or more major life activities, or someone who has a record of impairment. And by record of impairment, we mean that they have had past instances where they've had a disability, or they're regarded as having an impairment. They really may not have a disability, but the employer believes that they do and treats that employee like they are disabled. So a disability is a physical or mental impairment that substantially limits at least one major life activity. With the way that the law is now, there was an amendment to it, and in the preamble of that amendment, Congress pretty much said, we don't want you to be focusing on whether or not there's a disability. Rather, it's essentially presumed that most things are going to qualify as a disability. But a major life activity includes such things as caring for oneself, performing manual tasks, walking, seeing, hearing. If you have a physical or mental impairment that limits your ability to care for yourself, to perform manual tasks, walking, seeing, hearing, then you're going to have a disability. And then an employer is going to be prohibited from discriminating or retaliating against you because you have that disability. So under the ADA, employers are required to provide a reasonable accommodation for the known disability of a qualified employer applicant, unless providing that reasonable accommodation would impose an undue hardship on the employer's business. And establishing an undue hardship is a very high burden to meet. It's not that you can't establish that there's an undue hardship, but it's the exception rather than the rule. It's not a valid out to just say it's too hard for us to accommodate that. It poses an undue hardship. You've got to go through the analysis of an interactive process that we'll talk about in just a minute to make sure that there's no accommodation that can be provided such that you establish that there is an undue hardship. So you've got to go through this process that we're about to talk about to have an opportunity to really establish that you have an undue hardship. So a reasonable accommodation is any change or adjustment to the work or job environment that allows the disabled employee or applicant to perform the essential functions of the job or to otherwise enjoy the benefits and privileges of employment such that they're enjoying them equally as those non-disabled employees. So the reasonable accommodation requirement imposes a duty on the employer to engage in what's known as the interactive process. This is where you sit down and work with the employee to determine what reasonable accommodation may be provided to allow the employee to perform their job despite their disability. So the process should identify the precise exact limitations that the employee has because of his disability, and then identify the potential accommodations that could help the employee overcome those limitations. So the interactive process should include these four things. You've got to identify the essential functions of the specific job that the employee is tasked with performing. Without knowing the essential functions of the job, you can't know if an accommodation can be made to allow that person to perform the job. So you've got to know the essential functions of the job, and establishing what those essential functions are oftentimes comes from your job description. So it's important to have a current and up-to-date and doesn't have to be in great detail, but it needs to be sufficient to capture what the employee's job functions really are. And then you've got to consult with the employee to determine the specific physical or mental limitations that he or she has. You can't know if they can perform the essential functions of the job, nor know how you can help them perform those if you don't know the exact physical or mental limitations that that employee has. Because you've got to take those limitations into account when you decide, or not necessarily decide, but when you brainstorm to come up with potential accommodations, you've got to know what you need to be able to accommodate. So after you've come up with identifying the essential functions of the job, and then you've looked and know the specific physical and mental limitations that the employee has, then you need to consult with the employee to identify potential accommodations. What can we do to help you overcome this mental or physical limitation so that you can perform the essential functions of your job? And then you should select the accommodation that best serves the needs of the employer and the employee. However, in the interactive process, The employer has the discretion to choose among the possible reasonable accommodations. It's possible that you may sit down with the employee, go through the job functions, identify their limitations, and come up with 4 or 5 potential options of reasonable accommodations that can be done to allow the employee to perform the essential functions of their job despite their disability. So at that point, the employer has discretion to choose among those possible accommodations. Now, the employer is not obligated to select the accommodations the employee wants. It's very likely that the employee will prefer one alternative over another one. And in that instance, the employer is not obligated to select the one that the employee wants. Nor is the employer obligated to select what may be considered the best accommodation, as long as the one that they're selecting is effective and reasonable. The employer also can force the employee to accept the reasonable accommodation. They can say, this is a reasonable accommodation that we were willing to give you, and if the employee doesn't want to accept it, he doesn't have to. Now, at that point, if the employee can't come back to do the job and the employer's offered a reasonable accommodation, then the employee may lose his job. Now, that would be a high-risk termination. The employee could always challenge the reasonableness of the interactive process and the reasonableness of the offered alternative, and it would be a high-risk termination to terminate an employee because they refuse to accept the accommodation and come back. So lastly, the employer's duty to engage in the interactive process doesn't stop once you've done it. You've got to watch and make sure that the accommodation that's been given, that it's effective and it's really making it where they can do the job. Or it's possible that the accommodation or the disability may not be helped by it, and you may have to go through the process again to try to come up with another alternative to allow them to try. So here are some examples of reasonable accommodations. Unpaid leave, this is where you give more time off. We've talked about, in a minute, we'll talk about the FMLA. If they've exhausted their FMLA leave, which under FMLAs we'll see on the slide in just a moment, they would be entitled to 12 weeks of leave. With getting 12 weeks of leave, once that is exhausted, they may be entitled to more leave than that under the ADA as a reasonable accommodation. The amount of time of leave that they would be entitled to is a gray area. There's no hard and fast rule. The only rule that's clear is that indefinite leave is unreasonable. So leave for an unknown time period would not be a reasonable accommodation, but anything really between a few days, a few weeks, up to a year depends on the facts and circumstances of that case to know if it would be a reasonable accommodation. It's possible that longer than a year could be a reasonable accommodation, but once you get over a year, the harder it is for the employee to establish that it's going to be a reasonable accommodation. Another example is you may modify an attendance policy, you may modify a work schedule. Examples there, you may reduce the function of the job, you may provide additional breaks. They may offer part-time work, they may offer light duty work, or you may transfer or reassign the employee. On a transfer or reassignment, that's only required if there's a vacant position. And there's a split of authority, but the greater weight of authority says that basically the transfer or reassignment is not automatic, that you can require that the employee compete for the position with other applicants.